That word is no. A federal appeals court ruling today, no, you do not have immunity for the crimes you allegedly committed during your presidency. No, you do not have unlimited power. And no, you are not above the law. I mean, the court could not be any clearer on this point. And I'm quoting here, we cannot accept former President Trump's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, recognition, and implementation of election results. And going on to say, nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and to have their votes count. The court throwing out Trump's arguments that he shouldn't have to go on trial on federal election subversion charges. Trump, as you would expect, vowing to appeal to the Supreme Court. But he really only has until Monday to decide whether he can do that. Let's talk about now with senior legal analyst Norm Eisen and former federal prosecutor Joe Moreno. I'm so glad that both of you are here today. I mean, first of all, we have been talking about this for the better part of a month, Norm, right? The fact that it took this long perhaps is the surprising aspect. I mean, it was a 50-plus page opinion, but were you surprised that the outcome was this after this month?
No. You and I have agreed from the get-go that it can't be right. It's contrary to the whole idea of American law that a president could be absolutely immune if he sends SEAL Team 6 to assassinate a political opponent. Now, why did it take this long? 4 weeks is still very fast for by any normal standard, but they wanted unanimity, Laura. They wanted to get Karen Henderson, that Bush-appointed judge who's known to be prickly. She asked harder questions at the oral argument to join with Judge Pan and Judge Childs. They got that, and the resounding power of the opinion, the depth of the opinion, it's a landmark in what has been a long history of important opinions from the D.C. Circuit.
Wait, do we know that they were trying to persuade? Is that the reason why there was a delay, or that's the thought?
That's the assumption.
Okay.
Because given the speed with which they scheduled oral argument and the clarity of the views of two of the judges, you have to ask yourself, why did it take 4 full weeks? Pan and Childs were in a hurry. It must be that they were bringing Henderson along, and that was the right decision.
Well, you know, when you look at this, Joe, and you think about it was unanimous, and the court shot down this idea that there's absolute immunity. The court shot down the idea of double jeopardy attaching because there had been a political impeachment. They shot down these notions. Also the idea, and this is a really important part, about whether he was acting in his official capacity, so to speak. They were not convinced that the actions that he was alleged to have taken fell under the scope of a president. Is that right?
Well, I mean, and that was almost sort of an aside. It was actually in a footnote where they addressed that. And they said, look, it's not really in front of us, but if we're going to go there, if we would even consider looking back to the Nixon case and saying, okay, let's think about stretching that concept of immunity on civil matters to the criminal realm. It only applies to official acts. And we don't think this was an official act anyway. This wasn't the president executing his power. This was candidate Trump basically trying to say, I don't agree with the election results, I'm trying to change them. So they're basically saying, even if we went as far as you want, you're still not going to get there because it still doesn't fall within the ambit of what the Supreme Court has held as what arguably could fall within presidential immunity.
That double jeopardy aspect of it, I was so intrigued by that argument because when it was first raised at the oral argument, after, of course, the briefings, the thought was you can only criminally prosecute a former president or a president if they have first been impeached and convicted and, of course, removed. That struck a chord with so many people thinking, well, hold on. Does the president just then have to wait out, keep something hidden long enough to avoid impeachment, or have to convince maybe 1 or 2 or whatever number it is for the Senate? That couldn't be right. And they said it's not.
The number of presidents who have been impeached and convicted in American history is 0. I know that because I worked on the first Trump impeachment. So that would be the functional equivalent of giving a president the authority to commit any crime. winning the Oval Office would be a get-out-of-jail-free card. That can't be right. Now, it also turns the language of the impeachment judgment clause, which says, nevertheless, it doesn't say only if. So it turns the impeachment judgment clause inside out. I think the reason that was in there is expressed in the first 20 or so pages of the opinion, where they talk about jurisdiction. Can we even hear this case now as an interlocutory appeal before the trial is concluded? The rule is you can only hear the case if there's an express constitutional guarantee. So they were pointing to the impeachment judgment clause to get that interlocutory appeal. I think that was part of the reasoning.
Interlocutory meaning out of order, essentially. You get to have let me sidestep for a moment and have you decide this particular issue before we get back to the meat of the matter. Let me ask you on this scheduling, and you have different opinions, the two of you, on this and the idea of what's happening. He has until next Monday. Trump, not the Supreme Court. They cannot decide for the Supreme Court what their calendar is. But for Trump, he only has until next Monday to decide whether he's going to appeal this case. Otherwise, it has no impact on whether the underlying case gets stayed even longer and delayed. Do you see this as expediting, possibly getting back to Judge Chutkan?
I do. I think they made a point here at the circuit court where they said, look, you can try to get an en banc hearing, right, which we all know is most likely not going to happen. But if you
meaning
do
the
that,
entire Court of Appeals would hear the argument.
Very rare. But if you want to try to waste a few weeks or a few months trying to get that hearing, we're throwing this case back to Judge Chutkan at the trial level. So it's basically saying, go for the Supreme Court review. You might get it, you might not. But we're only giving you that period of time while we continue to freeze the case. Otherwise, it's going back to Judge Chutkan, and then she can resume things like pretrial motions, hearings, jury selection, and all of that. And that would minimize the delay.
Is that how you see it?
I think the Supreme Court on Monday the 12th is going to get, in just a few short days, is going to get an application for a stay. Trump is going to say, hey, pause everything, like the D.C. Circuit gave me the opportunity to do, pause everything while I present you with an application for certiorari, an application for the Supreme Court to hear the underlying merits, like they're hearing now in the 14th Amendment case. Right. They're going to have that for disqualification this week. Then it gets interesting. I think probably that stay, temporary stay, will be granted. But I think it's slightly more likely than not that the Supreme Court says we are not granting cert when they get to it, that they refuse to take it up. Nobody knows for sure. It's only a little more likely than not. But why would they want to thrust themselves into the middle of this controversy? Multiple courts have already held no immunity. The position is absurd that you can commit political assassinations in America. The Supreme Court can simply say cert denied, and then it does go back to Judge Chutkan fast.
You know, I think the idea that hypothetical continues to resonate with all of us as one of those moments when you risk losing your credibility if you do not answer the question in the obvious about what you cannot do. Joe, Norm, thank you both so much. I want to turn now to what this precedent means for today's landmark ruling. Does it set